Greetings and welcome to this evening's Colorado Law Talk. My name is Georgette Behill. I'm the Senior Director of Alumni Engagement and Outreach at Colorado Law. We are happy that you are here. During the presentation, you can ask questions using the Q&A function at the bottom of your screen. Questions will be monitored as they are submitted. Professor Harry Surden will respond to questions following the presentation. This Colorado Law Talk is a webinar, therefore only panelists can activate their video and microphone. Before we begin, I'd like to recognize that the University of Colorado sits upon land within the Ute, Cheyenne, and Arapaho Peoples territories. Further, we acknowledge that 48 contemporary tribal nations are historically tied to the lands that make up the state of Colorado. I'm excited to introduce Fred Bloom, Associate Dean and for Faculty Affairs and Research. Professor Bloom will serve as moderator and host for this evening's Colorado Law Talk. He joined the University of Colorado Law School faculty in 2012. Fred received his JD from Stanford Law School, where he graduated Order of the Coif. Professor Bloom's scholarship concentrates on issues of structure, method, and design in modern and federal courts. He teaches civil procedure, evidence, federal courts, and related courses. Thank you for joining me and welcoming Professor Bloom.
Good evening, all. Welcome. Thank you, Georgette, for that very kind introduction. Thank you to Yesenia and our incredible law school team for putting this event together. And thank you to all of you for joining us this evening. Our evening's Colorado Law Talk is about intellectual property and COVID-19, and our distinguished speaker is my beloved, wonderful colleague, Professor Harry Surden. Colorado Law's mission includes providing exceptional legal education, engaging legal research, and producing influential scholarship that impacts the real world. This scholarship does many things, including advancing our public service mission. The Colorado Law Talk series was launched in 2017 to share the groundbreaking research, knowledge, expertise, and ideas of the Colorado Law faculty with the broader legal community in the Denver area and beyond. Professor Surden's scholarship certainly fits that groundbreaking bill, and his expertise focuses on legal informatics, artificial intelligence, and the law, including machine learning and the law, legal automation, and issues surrounding self-driving autonomous vehicles. He also studies intellectual property with a substantive focus on patents, copyright, and information privacy law. Professor Surden joined the faculty of CU Law in 2008 and is presently a full professor of law with us. Before joining Colorado Law, he was a resident fellow at the Stanford Center for Legal Informatics, Code X, at the Stanford Law School. In that capacity, Professor Surden conducted interdisciplinary research with collaborators from the Stanford School of Engineering, exploring the application of computer technology toward improving the legal system. You can find out a lot more about Professor Surden's incredible scholarship, incredible teaching, and incredible service in the detailed biography that has been made available to you. But for now, I am delighted to turn the program over to my beloved colleague, Harry Surden.
Fred, thank you so much for that kind introduction, and thank you so much to Georgette, Yesenia, and the terrific University of Colorado Law staff, and also thank you to the administration, our new Dean Lolita Buckner Innes, and the great faculty and colleagues that we have. So it's my pleasure to be here today to talk about intellectual property and COVID-19. So let me begin. So today's talk will proceed according to the following structure. I'm going to give an overview of intellectual property law, and then we'll begin to talk about to what extent intellectual property law either helped or hindered some of the treatments or activities of the way society interacted on the basis of the most recent global pandemic. So let's begin. COVID-19, intellectual property, how do they interact? Well, I'm sure I don't have to remind you of last year, what happened only 18 months ago. Um, Back in January of 2020, an unknown disease started spreading across the world. At first, it was in distant countries, it seemed so far away. The risk was deemed very low, but very soon it started spreading from country to country and became a worldwide global pandemic named COVID-19. But what's amazing is not the way the pandemic spread, but the way the world reacted. I think there's a really inspiring and interesting story to the way our society responded to this emerging pandemic. So, just as an example, with just a few weeks after the virus being identified, the coronavirus, researchers in China actually synthesized the spike protein of the virus that creates COVID-19 and sent it around the world to scientists for free. It's an amazing accomplishment. Um, just a couple weeks later, the first treatment for COVID-19, remdesivir, was started to show positive results. Not that long after, there were whispers in early spring that they could have a COVID-19 vaccine. And this was unprecedented in the history of vaccines. We had never seen a vaccine done earlier than 5 to 8 years. Pretty soon later, we saw clinical trials showing positive results for remdesivir as a treatment for COVID-19. And then, remarkably, Pfizer was able to launch a clinical trial along with Moderna, get that clinical trial up and running, and in just a few months, they showed that the vaccine that they developed in a matter of weeks was initially 95% effective against COVID. Just a couple weeks later, the first COVID vaccines were given to the public, just a short 11 months after the virus was first discovered, by far the fastest vaccine in history. And then today, as of the current count, August 26, 2021, at least 203 million people have received the COVID-19 vaccine in the United States. So if we think about this remarkable whirlwind of events starting in January 2020, culminating in treatments and a vaccine where more than half the United States is vaccinated just a few months later, it's really a remarkable set of occurrences. So one question that might arise due to this, all these happenings with respect to COVID-19, to what extent did intellectual property play a role, either in helping or hindering this? And that's what we're going to talk about today. So before we get to that, let me just give you a brief overview of intellectual property law. I know that many or most of the audience are attorneys, but most of you are probably not intellectual property attorneys. So in case you didn't take intellectual property overview with me in law school, let me give you just a quick overview of the branches of intellectual property law. And that will help us understand to what extent intellectual property law has helped or hindered activities related around COVID-19. So in brief, there are four main branches of intellectual property law. There's patent law, copyright law, trademark law, and trade secret law. And we will see that to one degree or another, all of these different areas of law either have affected or have been affected by the COVID-19 pandemic. So let me just give you a brief overview of patent law. So patent law is also often called the Law of Inventions. The idea of patent law is to incentivize inventors to develop invest the resources, the time, the energy, the money, the lab equipment, etc., to developing inventions, whether it be the light bulb or the iPhone pictured here. Getting a patent is a really complicated and expensive endeavor. You have to apply at the patent office. Usually you enlist the help of a patent attorney known as a patent prosecutor. The process can take anywhere from 2 to 4 years and can cost anywhere from $10 to $30 to $50,000 to get it approved. And only some percentage of patents are ever approved by the patent office. But the idea is once a patent is granted, then you get a technological monopoly for 20 years from the date of filing. And so if you have a very successful invention, say a pharmaceutical drug that is a safe and effective treatment for a disease for which there is little or no competition, during that 20-year period, you have an effective economic monopoly, which means you can charge higher prices. And the goal of those higher monopoly prices are presumably to help you recoup the investments that you made in developing the invention in the first place. So that's the idea of patent law. A quite different area of law is copyright law, even though it has a very similar structure. So copyright law is a law of creative works, and creative works cover books, movies, television shows, music, art, computer software, and many other medium. But it's a similar idea in incentive structure. So in copyright law, you get the exclusive rights to your creative works, whether it's Star Wars or your book To Kill a Mockingbird and any derivatives. And during the duration of the copyright, you have the exclusive rights to make copies or works related from that. So, George Lucas, who originally had the copyright in Star Wars, had the exclusive rights to that, which he eventually sold to Disney for $5 billion. But because of that, he remained the sole arbiter of Star Wars merchandise and Star Wars movies and was able to monetize that. And there's a similar idea behind that to patent law, is that the creators of creative works get exclusive rights for some period of time. With copyright law, it's 95 years for corporations, or for individual creators, that's 70 years after the death of the creator. But the idea is during that time, you can recoup the profits, recoup the investments that you made in creating the movie or the book. And the idea is it would incentivize a class of creative works that we wouldn't otherwise have, in a similar way that patent law aims to incentivize a set of inventions, whether it's pharmaceutical drugs, that we believe society wouldn't otherwise have without that incentive. Trademark law is a little different. Trademark law is the law of commercial names, symbols, and slogans, whether it's the University of Colorado, Buff, the Apple logo, or the Tesla slogan. The idea behind trademark law is so that consumers can know the origin of their products and not be confused. So we wouldn't want another university opening up in Colorado that was unaffiliated and saying it was the University of Colorado. For that reason, the University of Colorado has trademark in its logo, and it has the exclusive rights to stop others from using that particular name. Similarly, Apple has the exclusive rights of the Apple logo and can stop other companies from producing knockoff Apple phones. And by that measure, consumers in the world can ensure that their products come from the Apple Corporation. Similarly, you can be ensured, thanks to trademark law, that cars bearing the Tesla logo come from the Tesla company and not from some other origin. So that's the goal of trademark law, to ensure quality and to avoid consumer confusion or consumers purchasing products that are unauthorized from different sources. And finally, kind of the less heralded area of trademark law, of intellectual property law, but still extremely important, is trade secret law. And we'll see how trade secret law interfaces with COVID-19 just a little bit, but I'll focus less on it. But trade secret law is the law of commercial secrets. The most famous commercial secret is the Coca-Cola formula, supposedly apocryphally hidden in a vault somewhere behind lock and key. But in general, trade secret is used quite frequently in business. A lot of companies have secret manufacturing processes or ways of doing things, and it's among the most widely used areas of intellectual property law. Okay, so with that little background in mind, let's start discussing the way that various areas of intellectual property law interfaced with the COVID-19 pandemic. So patent law, as we said, is the law of inventions. It gives you 20 years of exclusive rights. If you have a patent on a particular invention, you can stop in the United States, you can stop anybody in the United States from making, selling, or using or importing that invention. So when Thomas Edison had his light bulb patent, which presumably incentivized him, he was able to stop anyone else in the United States from making a light bulb that fit on his particular design that was represented in his patent document. And presumably he was incentivized to do that. So the first treatment to come out for COVID-19 was remdesivir from Gilead Sciences. And here you can see to the right is the patent issued in 2019. So the remdesivir, very important, and it really illustrates, I think, the central tension in modern patent law. So we think that Gilead scientists would not have been incentivized. Creating a pharmaceutical drug is an extremely expensive endeavor, costs hundreds of millions to billions of dollars when you include all of the research and development and also the clinical trials through the Food and Drug Administration for safety and efficacy that every pharmaceutical drug must undergo. So given that, pharmaceutical companies justify the extension of intellectual property rights, which lasts 20 years, although after clinical trials, typically it's 20 years from the date of filing. On average, about 10 years pass in research and development and also clinical trials. So the average pharmaceutical company only has about 10 years left of patent life by the time a pharmaceutical drug is approved by the FDA. And of course, there are many drugs that never pan out at all that cost a lot of money. However, on the flip side is during the life of the patent, pharmaceutical drugs are very expensive. So you can see that remdesivir costs $3,100 for a course of treatment. And of course, in many cases, people who are ill don't really have any choice but to pay the money if it's a life-saving drug and there are no equivalents. So on the one hand, we have this tension, pharmaceutical drugs are very expensive to create. So pharmaceutical companies justify their on-patent price for the remaining 10 years as a means to recouping those profits. But then interesting though, it gets a little bit more complicated than that, because a lot of the work that goes into pharmaceutical drugs actually comes from either federally funded research that comes from the federal government or done by the federal government or from universities. So there is an argument that a lot of the profits are being privatized by the pharmaceutical companies when in fact there was a lot of public effort that went into it, either from the government scientists itself or government funding or university funding. So it's a more complicated picture, and rarely does the government or the university profit as much as the pharmaceutical company. So that's a point to interrogate. On the other hand, remdesivir was not that effective, although it was a little bit effective. The most effective treatment to date for COVID-19 was a widely available low-cost steroid called dexamethasone. Now, it's low cost because it is not under patent. However, that too is a complicated story, because if you see to the right, at one point it was under patent. This patent is from the 1960s. Patents last roughly 20 years, although back then it was 17 years. And so by the 80s, the patent had expired. And once a patent on a pharmaceutical expires, it becomes generic. Generic companies are allowed to sell what are known as bioequivalents, which are essentially the chemical and biological equivalent to the branded version. And almost overnight, the cost of the drug plummets to somewhere just over the cost of manufacturing it. So at this point, this steroid, which is actually the most effective treatment that they found, clinically guided treatment for COVID-19, is super inexpensive compared to remdesivir, and it's widely available in many areas and highly effective. However, one might query whether we would have had this treatment at all had the original company back in the 60s not been incentivized by the patent system. And we will find that in 20 years, the remdesivir patent too will expire. So by the late 2030s, remdesivir will become a generic drug and its cost will plummet. So there is this real interesting tension that happens between the patent system, where in many cases companies are making a lot of profits off of pharmaceutical drugs related to COVID-19. On the other hand, some of the most effective drugs out there for COVID-19 are generic, but also incentivized by the patent system just at an earlier time. So I think that's really interesting. Of course, a really important question concerns the COVID-19 vaccine. So we saw this in record-setting time. You know, the vaccine was created in about 8 and went through clinical trials in about 8 months, which is unprecedented speed. So one of the major questions is, to what extent was the underlying technology for these vaccines incentivized by the patent system? In other words, or would we have gotten the same technology as society absent the patent system? And the general consensus is no, we would not have had this new technology. So what is this new technology? This is mRNA vaccine technology, exemplified by the Moderna and BioNTech Pfizer vaccines, which many of us have gotten. A totally new class of technologies, likely to change the world and change vaccine technology going forward. It's much easier to produce, much easier to amplify, much easier to target than traditional vaccine technologies, which relied typically on inactivated versions of viruses that were often grown in chicken eggs. So there are actually massive chicken egg farms out there in the Midwest where they grow traditional vaccines such as the traditional flu vaccine. So you don't have to do this with mRNA. So it's an amazing technology. It's one of the big silver linings of the COVID-19 pandemic. But then the question is, to what extent was this technology incentivized by the patent system? And I think there's a lot of evidence that the patent system really did incentivize this. So when you look at the story behind Moderna, which is a startup, they have a lot of patents around their version of the mRNA technology. They sunk a lot of money into it. Similarly, BioNTech, which is the company from Germany that partnered with Pfizer to create the Pfizer vaccine, they have a huge portfolio of mRNA patents in the vaccine context. So it's easy to believe that these companies would not have been around in 2019, 2020 when we needed them, or at least their technologies, without the patents behind them. So that's sort of the positive story of patents. And then Moderna, during the height of the pandemic, said, we vow not to enforce our patents temporarily during the pandemic. So that's sort of good corporate citizenship. On the other hand, vaccine maker BioNTech took the opposite approach along with Pfizer, saying we are not going to waive our patents. And I'm going to talk in a moment that that's a bit of a red herring, at any rate. But when I talk about whether patents should be waived or not during the course of the pandemic, one interesting story is the same story we saw with remdesivir. Behind Moderna's patent was actually a lot of public funding. So a lot of funding from the National Institutes of Health and a lot of research from university scientists. So again, even though BioNTech and Pfizer made $15 billion in profits off of their mRNA patent. Moderna's made billions of profits. Behind that is a lot of public funding, funding from taxpayers and universities that are essentially being privatized by pharmaceutical companies. So it's a complicated story. On the other hand, we will talk about the execution and bringing to market of these pharmaceuticals is actually about half the battle. So it's not just about inventing the pharmaceutical drug, it's actually commercializing it and getting to a level of purity and safety, which really only modern pharmaceutical companies have the expertise to do. So there's reasons to that the pharmaceutical companies should be part of that, but maybe not the whole thing. So we'll return in a moment to the vaccine story. So I've presented mostly the positive story. Interestingly, the U.S. Patent Office in the middle of the crisis reacted to this and said, we want therapeutics and technologies, and to the extent that the U.S. Patent Office is helping to incentivize and patents are helping to incentivize the creation of new therapies, we are going to fast track any therapies related to COVID through the Patent Office. So as I mentioned before, examining a patent can take between 2 and 4 years, far too long for a pandemic. So wisely, the U.S. Patent Office said, we're going to move any therapies related to COVID-19 to the front of the line and examine those first before we get to everybody else. So that's an interesting government innovation in response to COVID-19 from the U.S. Patent Office. But of course, one interesting thing to happen is whenever you have patents, you have patent infringement lawsuits. So this is kind of the dark side of patents in a lot of ways. The story I told you about the inventor spending a lot of money and then reaping the rewards of their profit is a kind of too simple a story. In fact, the patent and technological landscape is often very complex with multiple players who have contributed different parts of the technology, so the patent landscape becomes very complicated and overlaps. Even when Pfizer and Moderna began to release their vaccines, almost immediately companies began suing them, trying to stop them from releasing their vaccines for patent infringement. And that's kind of a dark story that during a pandemic, when we need vaccines, you could potentially have a patent infringement lawsuit against the leading vaccine makers who are trying to deliver shots in arms that could interfere with the health and safety of Americans. Of course, from the point of view of the patent holders, they may argue that they're not getting the money that they deserve, but it's a complicated story. So there's been a whole bunch of patent litigation surrounding COVID-19 therapies, some valid, some less than valid. Some of you have heard of patent trolls, which are basically companies that are in the business of buying patents and suing on them. Often it's for patents that are invalid or for whose patents exaggerate the extent to which they cover the technologies, and they basically bank on the fact that patent litigation is very expensive and more or less are able to extract settlements from companies using dubious patents, knowing that companies don't want to spend millions of dollars engaged in litigation to invalidate patents. So that's kind of a darker side of the patent story. Another side of the patent story is that the more patents you create, the more you create what's known as a patent thicket. So especially when they're lower quality patents, sometimes it inhibits the creation of new technology. So it's great that Pfizer and Moderna have these pioneering mRNA patents, but it could actually interfere with the work of researchers in the United States or around the world at universities who have to be concerned that their own university research, which may actually be advancing the state of the art and helping the pandemic, might infringe on active patents. So it's always a complicated story. One of the worst moments of the pandemic was, back in April of 2020, when ventilators were the preferred treatment for severe COVID-19. a company which had patents on ventilators threatened to sue on the basis of that. Hospitals and also major ventilator distributors, they quickly realized that was a public relations nightmare and backed out of that lawsuit. But the fear and uncertainty and doubt that it created really had lingering effects. Another good example right now, Theranos, a company that's gone defunct for basically a fraudulent technology. They've created, during their time that they were alive, they created a series of patents that are probably low quality, possibly invalid because largely the technology behind the company was a fraud. The founder, Elizabeth Holmes, is actually under a criminal fraud trial right now. But the patents that remain are actually out there, bought up by a lot of patent companies, maybe patent trolls, if you want to call them that, or patent assertion entities trying to profit off of these low quality patents. And some of these are inhibiting areas such as COVID-19 testing, which is really important. One really interesting backstory to the COVID-19 pandemic is the disparity around the world between the developed countries and less developed countries with respect to the vaccine. So vaccines are plentiful in the United States. Half the country is turning down a free vaccine. Meanwhile, in lots of lower income areas of the world, people are desperate for vaccines and can't get them and can't afford them. And one of the idea was that, hey, why don't we waive the intellectual property rights for the COVID-19 vaccines and allow pharmaceutical companies in countries like India and Brazil just to make the Pfizer vaccine or the Moderna vaccine without worrying about paying the licensing fees. For example, AstraZeneca, the Oxford vaccine, they are producing the vaccine at cost, which is essentially what happens in a generic vaccine. So the idea would be, hey, why don't we do the same thing? Let's just get rid of these patent impediments. There was a big call, open the intellectual property pledge, but not surprisingly, there was a lot of opposition from the pharmaceutical companies, both, I think, unprincipled and principled. On the principled basis, I think there is an interesting story that, again, we've seen that pharmaceutical companies, we probably wouldn't have these COVID vaccines that we do today without the incentive of patent rights of the past. So we don't want to set a precedent necessarily in a way that would deter future therapies. I don't think that's a great argument because I think there are plenty of profits to be made by making money in the developed countries by making things free or low income in the underdeveloped countries. So I think that's sort of not a fully baked argument. What I think is actually a reasonably baked argument is that waiving intellectual property rights isn't actually the bottleneck in vaccine distribution. It's actually in the production processes and actually in the trade secrets. So Pfizer, for example, has something like a several hundred point process for creating the vaccine in such a way that it meets the safety and purity standards that are quite apart from any underlying vaccine technology. In other words, you could actually give the vaccine away to a country in a less developed world, and they still wouldn't know how to make the vaccine or be able to make it without these knowledge of how to conduct these unpatented processes. So in other words, vaccines are not really the bottleneck, and I think that's true. On the other hand, it doesn't hurt to also waive these vaccines temporarily in countries that can't afford it. And that's exactly what's going on, because international patent law is actually based on a series of treaties through the TRIPS agreement and the World Intellectual Property Organization. The United States, as the government, has the ability not to enforce remedies if, say, a country like India were to allow the Pfizer or the Moderna patents to be infringed, and the Indian courts didn't enforce or enjoin that infringement. So that's really interesting, and that's a development happening. And I think it's a good thing. I personally think that there can be a balance during a pandemic of allowing access to the third world, and I think that the pharmaceutical companies are making plenty of money, enough to incentivize future vaccines in the developed world. Another interesting story is trademark law in COVID-19. So, of course, trademark law is the law of commercials, symbols, and slogans. So, all of us became familiar with this trademark in 2020 that we're using now. In fact, many of us had never heard of Zoom, back in 2018, although it's been around for multiple years, as the pandemic necessitated remote working. But now, of course, this is one of the Zoom's company's most valuable assets. There are lots of competing technologies, but if Zoom, the corporation, wants to signal you're using our software of our quality and not some other software made by some other company, they can aggressively enforce their Zoom trademark to prevent other companies from free riding on the goodwill. Another aspect of trademark law has to do with certification and ensuring the quality. So, as I'll show shortly, the N95, which we've all become familiar with, these are high quality medical grade masks that filter something like 99%, between 95 and 99% of particles. They're personal protective equipment used by hospitals everywhere. But the N95 that we see, of course, is a trademark by one of the government agencies, NIOSH, right? So NIOSH can use this to enforce quality, to ensure that we really don't want ventilators or face masks coming into this country that are simply stamped N95, but actually aren't the N95 quality in terms of reducing the particles. So that's a real danger, and this was a problem. There was a whole lot of counterfeit masks that were coming through. So aggressive trademark enforcement and customs impounding counterfeit N95 masks is part of the whole trademark landscape. Related, we never really thought about this, but trademark law involves certification marks, and up during the pandemic, a bunch of different nonprofit and government organizations arose to meet the need to deal with counterfeit goods coming through. Interestingly, trademark can be used to prevent price gouging, as so 3M famously during the height of the pandemic refused to raise their prices for their N95 face masks, but some third parties bought up a bunch of supplies and were advertising them under the 3M banner, and then 3M aggressively sued them because these third parties were engaged in extreme price gouging. So that's one way that trademark can be used, for the good during an emergency. Interestingly enough, during COVID-19, the Trademark Office saw a huge surge. The Patent and Trademark Office, of which the trademark is a part, saw a huge surge in trademark applications related to COVID-19, which is extremely interesting. And then, of course, the other day, many of us became familiar with this extremely awkward trademark, Comirnaty. So what is Comirnaty? Well, if you've been following closely, the Food and Drug Administration just officially approved the Pfizer-BioNTech vaccine. Prior to that, it just had emergency approval. Now it has permanent approval. And when there's permanent approval, a patented pharmaceutical will have a trade name and trademark name. And then eventually, when it goes off of patent, it'll have a generic name. So the trade name of the Pfizer vaccine that they chose is Comirnaty, spawning lots of humor and snarky remarks in social media. I think they thought it was a good idea because it was some sort of combination of COVID-19 community immunity and mRNA. I tend to agree it's a pretty terrible name. They could have come up with better, but it illustrates the point of trademark law. Trademark law is going to be important for the Pfizer vaccine to signal its place in the marketplace and ensure that knockoffs from unauthorized third parties aren't allowed to confuse consumers. Last but not least, we'll talk a little bit about copyright law and COVID-19. And this is more a story about how COVID-19 and the effect on society changed how we interact with copyright law, but there's a little bit of the reverse in there. March 2020, much to everyone's surprise, the world goes into lockdown. Businesses, offices start shutting down. Everybody goes home. We start interacting by Zoom. What are we to do at home? Well, of course, everybody turned to streaming. So 2020 was really the year of streaming. It's the year that streaming companies and content companies really up their streaming game. And of course, both the streaming of intellectual property is closely intertwined with copyright law. So thanks to copyright law, we all got to enjoy great hits such as Schitt's Creek or Ted Lasso on television streaming. Unfortunately, we also got things like The Tiger King, but you can't win them all. But intimately connected to all of these works of art are copyright law. So we imagine, for example, that the creators of Schitt's Creek and Ted Lasso wouldn't have spent the resources to hire the actors and put it together without the exclusive rights of copyright law afforded to them for 95 years. And that in turn allowed them to give exclusive rights to various streaming companies and prevent other streaming companies who are unauthorized users on the internet, using the threat or actual copyright infringement from preventing that. And that gives rise to the whole ecosystem that has given way to what is in many ways, I believe, the golden age of television, in my opinion, and largely due to copyright law in the backdrop. But of course, there's kind of our darker story. So hidden in the COVID-19 relief bill of last fall wasn't just COVID-19 relief measure, but was increased measures, anti-copyright measures. And as we shall see, more copyright is not always better. More copyright can be good, but too much copyright can inhibit creativity. So a story I always tell about is Disney. We're always, building on the past, standing on the shoulders of giants. So Disney as a company famously started out by making movies based upon the free and public domain stories of the Grimm brothers, like Snow White. What would their materials have been made of if they didn't have this rich treasure trove of non-copyrighted materials to make use of? And now Disney is aggressively uses copyright to stop others from building upon and making derivative or fan fiction works of their own works. So it's a complicated story. And as we saw this in the academic realm, as colleges moved online during virus fears, there was positives and negatives. So one of the big positives was there was a lot of online learning, a lot of sharing, a lot of collaboration across the internet in ways that were never possible. But also copyright law got in and interfered in a lot of ways, in ways that were a bit overreaching. So in copyright law, there's a doctrine called fair use, which allows certain unauthorized uses of copyrighted materials for usually for public benefit purposes like education, and some aggressive copyright holders were a little bit overly aggressive in enforcing copyrighted rights and tended to stifle some creativity, even though that activity was perfectly allowable under fair use law. Another interesting thing that happened was when students went remote, a lot of libraries and online services made their books free and available to students, but that also amounted to copyright infringement. So that was a robust debate as the publishers kind of sued back and said, hey, you can't just make our books, our copyrighted books, free to everybody just because it's a pandemic. That's not the way copyright works. To which they replied, well, maybe it should work that way. So, and there's a point to that. Maybe there's, you know, the way we waive, we're talking about waiving vaccine requirements, vaccine patents during the pandemic. Why not have a similar discussion about copyright? And then finally, again, you know, Zoom brought about a lot of really interesting issues, but one issue that arose, a lot of infringements that happen while you're streaming. So maybe people are playing music in the background, or sometimes people were streaming full movies, and that, you know, these were issues that really didn't arise until we all went into lockdown during the COVID-19 pandemic. That was really interesting. One of the really, I think, fascinating aspects of COVID-19 were the non-copyright issues, where copyright was given away for free. So the folks who first synthesized the spike protein of the coronavirus, which directly led to the vaccine, could have copyrighted their papers and charged scientists around the world. Instead, they distributed it widely, made it freely available for anyone to see, effectively waiving copyright. And that's a traditional norm in universities, where now the norm is that we distribute knowledge freely, as we're doing now in this video talk here. And then because of that, it really allowed tens of thousands of researchers to simultaneously work and collaborate on you know, research that directly led to the vaccine and remdesivir and all these other treatments without having to worry about the inhibiting aspects of copyright law. So that's a really interesting story of open source and collaboration. So that's, you know, just a snapshot of the way that the COVID-19 pandemic interfaced with copyright law, patent law, and trademark law, and vice versa, and the way intellectual property law was both affected by and affected by COVID-19. And I will pause there and answer questions.
Professor Surden, wow, thank you for that rich and detailed and thought-provoking presentation. Remdesivir and Ted Lasso in 40 minutes. That's pretty remarkable. We are, as you suggested, now open for questions. And our first question comes from Chris Miller. I think it's about sort of the intersection, perhaps, between two of the areas of intellectual property that you mentioned. And Chris asks, how can Big Pharma keep the processes it uses to produce the vaccine secret under trade secret law? I thought it had to disclose how to practice the patent in the patent application in order to receive the benefits of the patent.
Yes, that's a great question. So you are right that to get a patent, you have to disclose the major inventive details, but under patent law, you don't have to disclose what are known as production details and routine details. So, so for instance, you would have to disclose the chemical structure and anything that's not obvious inventively in the field for making the mRNA vaccine, you know, bringing the people in the field up to the speed. But the specific processes that you have for purification or for manufacturing, you can definitely keep trade secret. You know, that's somewhat controversial, but that's at least the state of the law at the moment. Great question.
Thank you, Professor Surden. So our next question comes from Richard Koo. And Richard, thanking you for your talk today, asks, much has been made of the government's investment in specific R&D programs, often to argue that the government is owed a return in the form of waiving patent rights or pricing control. One could alternatively reason that these are grants toward the advancement of American innovation or excellence, much like DARPA or the National Endowment of the Arts, and thus the return accrues to the country's economy as a whole. Your thoughts, Professor Surden, on which line of logic is most apposite?
That is a terrific question, and I think you are right. There's definitely something to be said that I think the economy does benefit when our pharmaceutical companies do well, and our health and welfare benefit when there are more treatments out there. On the other hand, my personal view is that it's gone too far to the role of pure privatization. So right now it is more or less 100% privatization of profits by the pharmaceutical companies. And I think it could be more evenly distributed back to the public in some way. I think we would still see excellence and treatments in the economy if it was 80% of the profits of patents that were the result primarily or significantly due to publicly funded research or some lesser amount. But great question.
Thank you, Professor. So this next question comes from Fred Bloom, and Fred Bloom is curious if you can kind of expand the geographic scope very briefly and talk to us about some of the more international implications of the intellectual property rights with regard to this global pandemic, particularly, but not only, Professor Surden, with regard to things like the WTO and TRIPS.
Yeah, I think it's really interesting that the Biden administration is taking a position that is basically against the position that's being advocated by the major pharmaceutical companies. And that's not something you normally see. Normally you see the United States government backing its major industries. And that's not necessarily a good thing, but that is, the major approach that you take. But I think there is the recognition that this is a complex issue, and due to global equity issues, this is really important. What I think is fascinating is the details as to how this works. So there's this kind of mythology out there that the United States is waiving the rights of pharmaceutical companies abroad, but that's actually not what's going on. What's really going on is when it comes to enforcing the rights in other countries, it's due to agreements, as I said, like the TRIPS agreement. And say another country, their courts choose not to enforce American patents, well, then you have to resort to treaty remedies and international organization remedies. And who are the bodies that enforce international organization remedies? Why, it's the government, right? So the government can choose to do what it wants, and it might have different interests than the private pharmaceutical companies. So the government's interest might be in preventing the pandemic, preventing mutations from happening in countries. So they might have different interests. But I think the dynamics of the institutions and the treaties are fascinating, whereas Pfizer in the United States completely and Moderna completely control their own patent portfolio. The government has nothing to say about the portfolio within infringement that's occurring within the United States borders.
Thank you, Professor Surden. Our next question comes from Kimberly Vudin, and Kimberly asks, did you see any patent lawsuits for PPE production by non-patent holder businesses or nonprofits?
I did, yes. So there was some aggressive trademark litigation for PPE production, but largely you saw it in the either patent holder and big trademark holders like 3M.
This question comes from Emma Cohen, and it might be a terrific question for you to offer some parting thoughts and to close. It's a big question and a very important question. In what ways do you think the patent system can be improved upon to better reduce the fundamental mismatch between the design of intellectual property protection and the policy requirements of effective pandemic response for the future?
Yeah, I think that is a really good question because I think there's been kind of a misfocus on patents alone without requirement of processes. So I think the principled objection that the pharmaceuticals companies have is, as I said before, is that it's not just the patents you need if you're going to make the vaccines in some other country. You need to know our secret processes, and you can't make us give that up under the law. But maybe we should think about that for certain emergencies. The Supreme Court has recognized that forcing companies to give up intellectual property rights is a taking. So we don't say that this should be uncompensated. The U.S. government has to pay for intellectual property rights including trade secrets that it forces to be revealed and made public. But I think in terms of looking something like a worldwide emergency like a pandemic, it's important to look at the whole life cycle, not just the patents, maybe the production processes, everything that's needed in order to effectively treat something like this worldwide, because it's really a worldwide humanitarian issue. The U.S. is part of a worldwide community. BioNTech is a German company that developed this, so we're benefiting from the works of other countries.
Harry, as you know, I always like to squeeze in one extra question, as my students know too, right? I always take every minute and more. So one more question, this one again from Richard Koo. Richard's question is, do you think that actions to weaken patent protection could materially shift companies toward favoring trade secret law for protection in this industry to avoid the obligations of disclosure? I think this connects back up to Chris's question as well, especially for methods rather than compositions.
I don't think so, because trade secrecy is much weaker. The pharmaceutical industry is heavily dependent on patent law. So the essential idea in trade secret law is that if somebody independently develops your invention, as long as they didn't take it from you as part of your trade secrets, your trade secret rights go away. And that is really problematic in the pharmaceutical industry. So this would mean if, say, Pfizer had, instead of patented mRNA technology, just kept it a secret, then someone else out there invented it on their own, and there's a lot of simultaneous invention that happens all the time. Both Moderna, BioNTech invented mRNA, for example. Your trade secret rights evaporate, and you can't do anything about it. By contrast, patent rights last for 20 years, regardless if somebody independently invents it after you. So it's a much stronger regime. So I don't think that's going to happen anytime soon in the pharmaceutical realm.
Thank you. Thank you, Professor Surden, really, both for those answers to those questions and for this incredibly informative and detailed presentation, the dynamic discussion. You've given us a lot to think about and a lot more to add to our discussions as we move forward, as we deal with this seemingly never-ending pandemic. Thank you for spending your time and sharing your expertise and your wisdom with us. Thank you all for being here. Again, thank you to Georgette and Yesenia for putting this together. Thank you all for joining us for this meaningful conversation. Next week, you'll receive a link to a recording of this presentation, as well as a survey to share your thoughts with us about how things went. Colorado attorneys will also receive a link for their CLE credit. If you are a former student of mine and I see you there in the participants list, please do send me an email and let me know how you're doing. All of you, both former students and not, please enjoy the rest of your evening. Again, thank you, Professor Surden, for this remarkable conversation.
And thank you, Fred.